And as per usual, you will get the recording afterwards through the email. You will get the link, you will get the PDF, and you will be able to go through this webinar later on again. When it comes to the questions, I would kindly ask you to write down your questions and send them afterwards to an email that will be shown. So I will start also sharing my screen. Allow me just a second. Okay, so here we are. So as I mentioned, please send your questions after the presentation to the following email, diatomic.innocence@gmail.com. We are doing this for the reason of being more efficient and just being able to collect all of your questions. Some of them might overlap, and for those who are not able to attend today, to have a wider picture on all the questions that could arise. Furthermore, I hope that all of you are doing well considering the situation. And unfortunately, in the case that internet breaks down for any of us today, I really hope it's not going to happen, but I apologize in advance if there are any technical difficulties on our behalf. So let's begin. The legal aspect of launching a business is one that is too often overlooked by founders. And that is also the reason why we decided to tackle this topic. So it's true that focusing on the development of the product, recruiting the right team, and mapping out a business plan are company's priority in the first moments following the creation of your business. And that's completely normal because it's normal to start with your idea, with all the complexities around your idea and building up a business, let alone thinking about all the lengths that you need to go legal-wise. Nonetheless, no matter how time-consuming and frustrating the legal process is, it's definitely something that is unavoidable, and it's something that you need to do right from the start if you don't want to have bad surprises further down the line. Before I continue, since I'm getting some notifications on the internet not being quite good, I would just like to ask if all of you are actually hearing me well. Please unmute your microphones and just let me know if you can hear me loud and clear.
No, I was having a lot of difficulty in understanding.
Okay, is the connection interrupted or am I speaking too fast?
Interrupted.
Interrupted. Okay, so fortunately, since I am the one recording, the recording should be actually in order once we are done with the webinar. And worst case scenario, we will do the following. After the webinar is done and I go through the recording, in case the recording is not good, I will record one on my own without participants and provide it to you. Is that okay? Okay, I will take that as a yes. Okay. Just have a look. Okay, so as I said, I will provide the video without interruptions in case this one is corrupted. You will not be asked to participate twice. Okay, so let's move on because this is going to be a bit of a longer webinar today, and let's get down to it. Okay, okay, you'll see it, perfect. Okay, then no reason to waste any more time. So the EU as such is great for doing business. It is a complex machine, it is a bureaucratic system. However, it is the strongest advocate for supporting entrepreneurs and making your life easier. Today, I will go through some basics of starting and conducting your business in the EU. I will mention relevant EU law, especially intellectual property and GDPR. And lastly, we will tackle a bit on how the law is changing and what we need to pay attention at in the state of crisis, such as the current one that we are facing. So first of all, there are some general requirements for doing business which are stemming from the European Union. So the EU encourages all countries to meet certain targets in order to help set up new companies, including that setting up should last no more than 3 working days, that setting up should cost less than 100 euros. All the procedures should go through a single administrative body, and you should be able to do all this online. Further down the slides, I will show you the national contact points that might be very useful in this regard of registering a company in another EU country online. So here on the slide, you can see on the top right corner something that starts with as an EU citizen. So first of all, we need to always keep in mind that perhaps our co-workers, our employees might not come from the EU, and therefore different legislation applies. As an EU citizen, you are of course entitled to set up your own business, as it says here, even as a sole trader in any EU country, but also thankfully to trade agreements to also Iceland, Norway, or Liechtenstein. You can also set up subsidiary branch of an existing EU-based business that is already registered in one EU country. So on this slide, we actually see some more specific requirements: location, entity structure, intellectual property, and human resources. Obviously, when you were starting your company, you were taking into consideration the location for various reasons. Within the EU, countries have very different administrative processes and taxation systems, but that should not be what determines where you launch your business. As I already mentioned, you do have your businesses, but it's good to always have this something as a point of reconsideration or something to consider anew if you are starting a new business in another member state. So you need to look at the ecosystem and go for the one that will best serve your business's interests in terms of resources, network, market, and talents. What is important to keep in mind is that when it comes to business trading in Europe, for sure, each of you can benefit from the EU single market and also from certain trade arrangements with other European countries. So this means that most goods can move freely within this territory without any extra costs or quantitative restrictions, and this is known as free movement of goods. However, certain goods, such as excise goods and chemicals, are subject to additional rules, and you should also be careful when it comes to different VAT obligations depending on what you sell, to whom you sell, and the destination where the goods are transported to. One of the important aspects is definitely taxation. It is important to emphasize that the power to tax is actually in the hands of the member states. So you always need to keep in mind that you should look up the national legislation of the member state where you do your business. The EU is having only limited competences. On the other hand, the EU tax policy is geared towards running the single market smoothly and harmonization of indirect taxation before direct taxation. There's also the fight against harmful tax evasion and tax avoidance. And there are some tax measures which are adopted on an EU level that you have to be aware of as a business owner. So first of all, you need to be aware of national rules on company tax, so company law, including how to register for company tax, how to prepare a company tax return in the countries where you operate. And specific EU rules apply when you have your parent company in one EU country and subsidiaries in other. There's also important to keep in mind that as of January 1st, 2018, new rules entered into force, obliging member states to give tax authorities access to data collected under anti-money laundering legislation. So the anti-money laundering directives aim to prevent the use of European financial system for money laundering, also for terrorist financing purposes, but that's another topic now. And this actually means that national tax authorities will have direct access to information on the beneficial owners of companies, trusts, and other entities, as well as companies' customer due diligence records. So this is also one thing to consider when you're starting your business or starting a new business in terms of location, the taxation, administration, and of course, the entity structure. So all of you have already decided what the entity structure of your company, so startup, SME, and so on, will be. However, throughout the life of your company, you can also restructure, or you can choose another entity structure for your new business. So the right entity for your business does not depend so much on where you are launching your business, but on what type of business you are considering. So we can choose between sole proprietorship, partnership, corporation, or an LLC. Usually people are choosing the LLC, so company with limited liability, because you need to take this into consideration. So legal liability, tax implication, administration, the amount of flexibility you want, and of course, future needs of your business, because each of them have their advantages and drawbacks. So when we're talking on an EU level, you can always use some services such as EU Go, which you can see in the top left corner of the text box, so below the text, along with the link. When it comes to the contact points, platforms, and so on that I will be mentioning in the presentation, the links are going to be both in the slides and at the end of the presentation, gathered all as some sort of a knowledge base, so useful links. This link in particular will lead you to points of single contact, or PCS, and they are e-government portals that allow service providers to get the information they need and complete administrative procedures online. So basically you go, you click, you choose the country where you're doing the business or want to open up a business. And you can explore business opportunities, expand your services to another EU country. You will get links to necessary legislation. And obviously learn more about the rules and formalities that apply, which is probably the most important thing that you need. Okay. So the next thing that is often neglected is the legal aspect of human resources. So once again, this is something that EU makes easy for you. If you hire an employee within European Union, or actually with the nationality of any of the countries of the European Union, no visa is needed. The freedom to move to another EU country to work without a work permit is a right for all EU nationals. But if members of the team come from outside the EU, or if the person that you want to hire is a third country national, so coming from outside the EU, you have to keep an eye on the national legislation, which sorts out the visa conditions, work permit, residence, type of insurance they might need, as well as perhaps some sort of a guarantee or sponsorship. On the other hand, there is a category of non-EU nationals that may have the right to work in an EU country or to be treated equally with EU nationals as regards conditions of work. So these rights depend on their status as family members of EU nationals and on their own nationality. So they might be family members or spouses of EU nationals, and that could actually extend their own rights. Furthermore, although some countries are non-members of the EU, their nationals can work in the EU on the same, so equal footing as EU nationals, since they belong to the European Economic Area. So workers from Croatia may face temporary restrictions on working in Liechtenstein because they impose quotas that limit the number of people who can work and live there. But on the other hand, under the EU-Switzerland agreement of the free movement of persons, Swiss nationals are free to live and work in the EU and vice versa. When it comes to the United Kingdom, the entire EU law across all policy areas will still be applicable to and in the United Kingdom during the transition period. And it is currently foreseen that the transition period ends on 31st December of 2020. It's also good to know that many European governments are actually taking the initiative to facilitate this process, offering some sort of incentives or faster administrative process when it comes to workers in high demand and workers that are highly skilled. The next point is intellectual property. So it's understandable that once you start a business or you are in the early stage, intellectual property is not something that's necessarily considered as a priority. However, protecting your intellectual property or IP is of crucial importance when starting and conducting your business. Whether it is to protect ideas from competitors or a formality to do before recruiting your team, it will not hurt to know what your options are. So depending on the nature of your product, of your service, you might be using some digital services which are available in certain countries and not in others, for example. Or your online services have to abide not only to national rules, but also to the EU ones or international ones. So the matter of innovation is the main concern for any business relying on innovative technologies, products, for any business that wants to be up to date and stay competitive. Many small businesses or young entrepreneurs do not understand various types of intellectual property and the protection that can be ensured for their products and services. So what is necessary is effective management of IP, and that should be one of the basic elements of the company's development policy. This may significantly influence the increase in competitiveness in the market. Management of intellectual property in a company consists of following things. So development of IP, market analysis, protection of intellectual property rights, sharing the know-how and selling of the rights in possession. The companies can usually choose an active strategy, passive strategy, or what happens as well, to entirely ignore the existence of intellectual assets and their economic significance. However, the third is the option nobody will recommend you. Obviously, larger companies are those which can allow themselves to choose an active strategy because they possess greater financial resources and most possibly already play a significant role in the market. A young company will usually select a more passive strategy, spending smaller amounts of money on the development and protection of intellectual resources. However, this is not really the approach to protection of intellectual resources that you should take on. Why? because naturally the cost of obtaining patents, especially in the European or international procedure, can mean large expenses and complicated administrative procedure. However, such a patent should protect the basic technology of a company and its competitive advantage. So you can ensure income from licensing or make the company more attractive for the investors. Okay, so to Yorgos, as I have previously mentioned, I will provide later on a video which is without interruptions. I really apologize in advance, but due to this situation, everybody's using internet, so the bandwidth is significantly worse. I apologize once again, and we will do our best to provide a video without any interruptions. So I hope you can still follow as much as possible, but at any rate, you will not be, let's say, harmed or damaged, and you will get the full webinar. So, as I was mentioning, due to financial limitations of young businesses, they can opt for this passive strategy, or they can opt for choosing unpaid intellectual property protection. So protecting their intangible assets through company confidentiality and copyrights. So here you can see the 5 essential intellectual property considerations for a new business. So to consider both at the founding and at an early stage, you should transfer the intellectual property to your company. So problems arise if one of the investors or creators leaves the company and claims ownership of a crucial invention or creation. In order to avoid this, the creators should transfer all intellectual property to the company, and failure to do so may be a red flag for investors. Then you should choose a great name and make sure that you can use it. So from legal point of view, there are 2 aspects that make a good name. Firstly, the name must be the one that can actually be used without infringing prior trademarks. You should use an IP attorney to do proper searches before picking and committing to a name. And secondly, the name must be one that can be protected and owned. The criteria for protectability varies from country to country. So again, it's national legislation that you need to look up. But generally speaking, the name must be distinctive. The next thing would be to trademark your name. So protect your name with a trademark. You only have rights to do that name if it's protected as a trademark. One of the most valuable assets of a modern business is a known and appreciated trademark, product name, packaging design. So these elements create the market identity of a company and often determine the ability to generate profit. Also, the rights to use the created or purchased technology, construction solutions, created inventions, or industrial design have a significant influence on the value and market standing of your company. Also, the perspectives for its further development. Another crucial issue is the company's confidentiality, which can be of strategic significance for its development. In the case of young businesses, the first important element of intangible resources is the idea for a new business itself, the knowledge regarding the chosen business profile, and that can be a strategic resource. Company registration can give limited protection. In many countries, actually, it can receive weak or even no protection against the use of later trademarks. So trademark protection is a relatively inexpensive form of IP protection, and failing to do so may lead simply to a situation where the name must be changed later on, which is damaging you long term. And obviously, trademarks should be protected in those countries where you intend to do business. The next question would be to patent or not to patent. So this decision should be done before your invention is disclosed publicly. So your invention, solution, product. For example, by pitching in some sort of a competition, you may actually lose the patentability of your invention. And same applies to the designs, for example, a product's shape or user interface. And obviously, if you are in doubt, you should always consult some sort of a legal expert or the best possible solution, an IP attorney or a lawyer. So you should also remember that patent application will eventually become public and it will provide crucial information about your invention to the competitors. Another option that you have is simply to keep your innovation secret. So the advantage of trade secrets is there is no registration requirement, the protection is not limited in time, and the most notable disadvantage is that you are not protected in case of reverse engineering. So everything comes with a set of advantages and disadvantages that you need to consider. Lastly, remember intellectual property when hiring and contracting. Why? In many countries, transfer of IP is not automatic from employee or contractor to the company. For example, if an employee or contractor creates a brochure, logo, user interface, or other materials, it is possible, or even likely, actually, that copyright belongs to the creator and not the company. So the easiest way to make sure that all IP belongs to the company is to include this assignment provision in employment and procurement contract that your employees would have to sign. There is also one thing to keep in mind. If you opt for crowdfunding, which in itself is a great way to introduce new products, get paying customers, gain publicity, you have to understand that this entails not only great potential, but also significant IP risks. For instance, the company TikTok, which some of you probably know, designed some sort of a premium conversion kit to make iPod Nanos into smartwatches. Regardless, since they were on Kickstarter and it was amazing, at the point where they wanted to market their solution, the market was completely saturated with knockoffs, and regardless of the fact that the idea was brilliant, there was simply no market gap anymore, but a bunch of copies of the same product. Okay, so the next thing to consider is GDPR. Although brought or actually entered into force in 2018, it is still a source of many headaches, to put it that way, for especially smaller businesses and those who cannot afford a compliance officer or a lawyer, data protection officer, and so on some sort of a regular basis. Nonetheless, there is always something that you can do and keep in mind, be aware of in order to be GDPR compliant. So above all, you need to know that GDPR, as its name states, is a regulation. But what that means is that as opposed to EU directives, it is self-activating and legally binding on its enforcement date. So what matters here is to first know its territorial scope. It is substantially larger than was previously under the previous data privacy EU directive. And it applies to any company that is doing business with or processing personal data of EU citizens, regardless of where it is established or where the actual processing or personal data takes place. So this means that even if a company is not based in the EU and there is no processing of personal data in any EU-based facility, either the offering of goods or services to EU citizens, or the simply tracking of EU citizens' behavior, for example, through the cookies, that's already enough for the company to be subject to the regulation. So that's a very important thing to keep in mind and to kind of distinct whether you are falling under the scope of this regulation, which most probably, so 99.9% you do. Why is it being introduced in the first place? So basically the EU wants businesses and organizations of all sizes to take increased accountability for all the data they collect. Up to now, data protection was typically tick the box, and that was all. The customers, the users were not really fully aware on what they are agreeing to. So the EU now wants to take a step back with the companies and make them check what kind of data they are collecting, make them consider how they store the data and how they take care of it. Additionally, GDPR makes consumers and end users more aware on how their data is being used. So the aim is to give individual data subjects a deeper understanding on what organizations are doing with their information. And as a business, you need clear signposts all around your website about what's happening to users' data, for example. What is important to keep in mind is that when you're using third-party data services, such as Google Analytics, for tracking browsing data, you will need a proper contract with them. And obviously need to take GDPR into consideration. And you really do need to take this seriously because it applies to all businesses, and even smaller businesses can face fines of up to 20 million euros. So which are the main changes for your company, which followed entering into force of GDPR? Those are accountability, user rights, consent, security and privacy obligations to your sub-processors, and vice versa, and data breach notifications. So I have to emphasize that this list of these 5 points is just a list of 5 main points. It's by no means exhaustive. There's plenty of other things that you have to take into consideration, but these are the most important ones. So first, accountability. Your company is responsible for and must be able to demonstrate compliance for the data that it controls, that it processes, that it gathers. This means that you must be able to document and to prove how you ensure data confidentiality, integrity, and security. You must also justify the lawfulness of processing. So you have to make sure that it's adequate, relevant, and limited to the processing purpose for which the data have been provided, so collected actually. Enhanced data subject rights mean that the new regulation empowers users with the right to be informed. So I'm talking now about the second point. The users have the right to be informed about what type of data you keep about them and the respective processing. Not only that, it also gives users the right to access, rectify, or export their data. Users also have the right to object to processing and have their data erased. They also have the right to be forgotten if no longer using the service. They have the right to restrict or stop processing, so to request for you to stop processing their data. They can lodge a complaint, and they have the right not to be subject to decisions solely based on automated processing, for example, in hiring process. So supporting these rights is mandatory, and you should enhance your services or websites to be able to support them. Additionally, you need to be able to demonstrate that you support them. So implementing logging and timestamping will come very handy for you. The next in the line is consent. So users' consent is one of the 6 legitimate reasons for processing personal data. It should be freely given by a clear affirmative act. So what does this mean in practice? It means that if you on your website, you have ticking box for the consent, yes and no, or I understand, I agree, or I do not agree, have to be clearly marked. And there should not be prematurely tick the box, but they really have to click on it. Also, the size of the boxes has to be the same in order not to influence their decision, and so on. So silence, pre-ticked boxes, or inactivity do not constitute consent. Consent should be given separately for each processing activity involved. For example, different for each service you provide, different for marketing. You need to record user consent and make sure that it is just as easy for the user to withdraw as it is to give their consent. The next thing in line is security and privacy obligations. So in case you're doing business on a cloud or having some sort of cloud and sub-processors in the process of conducting your business, and nowadays most of the businesses do, then you have to tread carefully. You must make sure that not only you follow the GDPR, but your sub-processors as well. So you have to make sure that you flow down your security and privacy obligations to your sub-processors. And this is actually one of the most heavily criticized aspects of the regulation. Why? Because it transports this obligation to you. So it is extremely difficult to achieve GDPR compliance if your company performs outsourcing and then a cloud-related service model, because you have to review the third-party services you need and ensure that both of you meet security and privacy obligations sufficiently. However, on the bright side, this is something that you can always reflect in your contracts once you start doing business with these third parties. In case you already have them, you can always modify your contracts or consider alternatives. Sorry. So the next in line and the last one on this list is data breach notifications. So this is extremely important. Data breaches resulting in risks for individuals must be communicated to the supervisory authorities, and in case of high risk, the affected individuals within 72 hours. So if your company is not located in the EU, but is subject to GDPR under the scope that we already discussed, then you should appoint an EU representative. In case your company performs processing on a large scale of sensitive data or some sort of regular systematic monitoring of data subjects on large scale, then you actually have to appoint a data protection officer. Finally, it may be required of you to perform a data privacy impact assessment in order to assure that you evaluate and address risks for the personal data of individuals in your company's operations and services. You have to decide what is the data that you really need. So acquire and process only the minimum set of data that you need for processing purposes you have a legitimate basis for. For example, due to legal contract with the individual or by means of obtaining consent. Ensure that this data is exposed to the people that really need them in order to perform their tasks. And obviously sharing other people's data with anyone out there will surely get you into trouble. So take this into consideration as well. The next slide is, again, a little list that I put together for you, some things to take into consideration. Again, it is non-exhaustive, and I will not tackle each of them in particular, but rather I will just tell you a bit more on why the GDPR and data security is so important. So you have a general obligation to implement technical and organizational measures to show that you have considered and integrated data protection into your processing activities. You should explicitly embed privacy by design and security in your services, in your daily operations, and ideally from day zero. And this is the only way to ensure GDPR compliance and meet your ethical and business obligation to keep your customers' data secure. Obviously, ignoring security opens the door to all sorts of trouble, which can destroy not only GDPR compliance, but essentially your customers' trust and your business in the end of the line. What you're facing for non-compliance is actually a great fine. So as I previously mentioned, you can be fined a maximum fine of 20 million euros, or in the case of undertakings, up to 4% of global turnover, whichever is higher. But there are some other measures. So corrective actions from the supervisory authority, fines from the supervisory authority in which this 20 million falls under, damages in case of a lawsuit, and obviously a reputational damage, so a damaged brand or bad publicity. As I previously mentioned, the links, useful links will be provided on the last slide, so you can also take a look, because I imagine that most of you will not open the regulation itself and start reading it thoroughly. There are many good knowledge bases on what are the steps that you need to take. And I really do hope that this webinar today has provided a valuable insight for you and some sort of a starting point, either for when you are starting your business or already conducting it and you became aware that there is something that was lacking in your conducting of business so far, whether it's intellectual property, whether it's GDPR, obviously company law, as we tackled it in the beginning through the entity structure. Lastly, having in mind the situation as it is currently with the pandemic of COVID-19, we also have to take into consideration how is this going to reflect on all of the businesses. Obviously, each member state will coordinate the economical help or boost on a national level, and on this account I cannot provide more help, and economic measures on behalf of the EU are only to be seen. However, there has been a communication from the EU that might be very useful at this moment, and it has been provided by Chair of the European Data Protection Board, Andrea Jelinek, who stated that data protection rules, obviously such as GDPR, do not hinder measures taken in the fight against the coronavirus pandemic. So it needs to be underlined that even in these exceptional times, the data controller must ensure the protection of the personal data of data subjects. And therefore, a number of considerations should be taken into account to guarantee the lawful processing of personal data. In the employment context, the processing of personal data may be necessary for compliance with the legal obligation to which the employer is subject, such as some obligations relating to health and safety at the workplace, or to the public interest, such as the control of diseases and other threats to health. So the GDPR also foresees derogations, or let's say negations, to the prohibition of processing of certain special categories of personal data, such as health data, where necessary for reasons of substantial public interest in the area of public health, obviously. And it's on the basis of union or on the basis of national law, or where there is need to protect the vital interests of the data in subject. The questions that you see on the slide are only some of the questions that are responded to through this communication, and it is something that you have to keep in mind and be up to date with the national measures that your member states, with the member state where your business is bringing about. As I have mentioned at the beginning, here is a list of some useful links on how to start and conduct your business. And as previously mentioned, please direct all of your questions to diatomic.innocence@gmail.com, which is an address that I put on the first slide. And we will try to provide extensive answers to your questions, as well as webinar in its entire length without interruptions. You will be getting this presentation, or actually a PDF, along with the recording on your email, as per usual. And I really hope that most of you managed to hear most of this webinar, but as I previously mentioned, you will not be harmed in any way. I hope that you are all in the safety of your homes. And until the next email, I would like to thank you very much for following the webinars, and thank you for your patience. All the best, and keep in touch. Goodbye.